Good day, Crime Talk aficionados. We have another great show for you today. First, the Bryan Kohberger matter, trying to understand why. A Georgia teen charged with murder of a mother and her stepfather. For all those aficionados who are total legal geeks, how about a little case study on judicial interpretation? The death penalty is imposed on Ryan Cole for the murder of a 15-year-old Kyler Edmond. Bad dude. The Declaration of Independence was read to General Washington's troop on this day in legal history. The quote of the day has to do with a criminal mind. And wait until you hear what our dumb criminal stole. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. Now, you know the drill. Subscribe if you haven't, like if you do, leave me a comment below and hit that little bell for notifications. Now, we really appreciate you subscribing. Just the other day, we were at 299,500, and now we're over 204,000. So I want to thank everybody for doing that. I do truly appreciate it. And hey, if you want to support the channel, it doesn't cost you a thing. Just hit that subscribe button. Thank you very much. Now, before we get to the docket, let me remind you to go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do a background search literally while you wait, and the results are sent to you within seconds. It is beautiful. And it's going to have all types of information that you want to know about somebody. You're going to get phone number information, subscriber information that they have as it relates to social media, right? What is their social media presence? You're going to get their email address. You're going to find out if they're married. Are they divorced? Do they have liens, judgments? Do they have a criminal history? Are they on a sex offender registry? All those things that you want to know, but maybe they're not going to tell you. And most importantly, if you do a background search and you find out your spouse or your boyfriend has all these email that he doesn't tell you about, is it because it's for those dating sites that he may be on? Go check it out. crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for Wednesday, July 9th, 2025. And first on the docket, Bryan Kohberger trying to answer why. So let me give you a little background for all the people who haven't been following the story. But if you're Crime Talk aficionado, you've been here a while, you're familiar with the facts, but there's a lot of people that aren't familiar that are just tuning in. So let's do a quick recap. So back in November 13th of 2022, 4 University of Idaho students, Madison Mogan, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin, were brutally stabbed to death in their off-campus home at 1122 King Road. They're in Moscow, Idaho. The perpetrator, and we know this to be true, Bryan Kohberger, a now 30-year-old former criminology PhD student, well, he pled guilty on July 2nd to those 4 counts of murder and 1 count of burglary, accepting 4 consecutive life sentences without the possibility of parole. So let's consider some insights with various reports exploring Kohberger's background, his potential motives, the role of his academic studies, his likely future in prison, and the potential risks he may face as a target in prison. Boo-hoo. All right, first, let's talk about his academic journey, right? Kohberger's academic path was steeped in study of criminal behavior. Beginning back in 2018, he pursued a degree in psychology with a forensic track at DeSalle University in Pennsylvania, later earning a master's degree in criminal justice in 2022. He then enrolled in the PhD program in criminology at Washington State University, conveniently located near Moscow, Idaho. And at DeSalle University, Kohberger studied under Dr. Catherine Ramsland, a renowned forensic psychologist known for her work with the serial killer Dennis Rader, also known as the BTK killer. Now, Dr. Ramsland's courses such as psychological sleuthing exposed students to simulated crime scenes and real-life cases studied of notorious killers, including Ted Bundy, Elliot Rogers as well. Now, Kohberger engaged deeply with the material described by classmates, a guy by the name of Josh Ferraro and Brittany Slavin, as diligent, intelligent, but socially reserved, particularly around women. Now, Ferraro noted that Kohberger was reluctant to engage in small talk, while Slavin recalled his quiet demeanor with no overt red flags indicating some sort of violent tendency. Well, Kohberger's coursework included analyzing the motives and methods of killers, and in 2022 he posted a Reddit survey targeting ex-convicts, asking questions like, why did you choose the victims? And how did you leave the scene? Around the same time, he ordered a K-bar knife with a 7-inch blade, later identified as the murder weapon. Now, these actions raise some serious questions about whether his studies may have influenced his actions. Now, Dr. Ramsland, reflecting on her role, expressed concern in a July 2nd, 2025 interview that she gave, stating, quote, I have to look at the framework of what I taught and wonder, did I inspire him in some way, end quote? However, she later clarified in an email, quote, please do not represent me as thinking I planted the seeds. Some, quote, students enter because they're already inclined, end quote. So, Dr. Carol Lieberman, a forensic psychiatrist, proposes a motive rooted in Kohberger's personal history of rejection. She highlights the physical resemblance between the victim, Madison Mogen, and Kaylee Gonzalez, and Kim Kennelly, a middle school cheerleader who apparently rejected Kohberger's advances. Now, Kennelly's mother recalled Kohberger leaving, quote, love letters, end quote, and making awkward declarations met with dismissive responses. Lieberman suggests Kohberger's rage from this and subsequent rejection, such as a disturbing 2015 Tinder date incident, culminated in a revenge killing targeting women who symbolized his unattainable desires. Lieberman draws parallels to Elliot Rogers, the 2014 Isla Vista killer, whose incel manifesto, studied in Kohberger's classes, railed against women for rejecting him. And Kohberger's victim, particularly Mogen and Gonzalez, were outgoing, blonde members of the Greek life there on campus, mirroring Rogers' targets. Kohberger's behavior, such as following Mogen and Gonzalez on Instagram, messaging them, and visiting their workplace, suggests premeditation. Cell phone data obviously indicates his device pinged near the victim's home some 23 times in the 2 months prior, often at night. Now, this theory also further fuels speculation of a social media account named Papa Roger, which posted in a Facebook group about the Idaho murders. Specifically, on November 30th, 2022, the account referenced a large fixed blade knife and a sheath, details later confirmed by police. The account's cartoon icon resembles Kohberger, and its posts ceased after his arrest in December 30th of 2022. Jumping back to the classmate Ferraro, noted that Kohberger's studies covered killers returning to the crime scene, digitally or physically, suggesting the account could reflect Kohberger's reliving his crime. So we do know Kohberger entered the victim's home through a sliding kitchen door about 4 a.m., targeting the third floor where Mogen and Gonzalez slept. Prosecutors believe he intended to kill one or both women, but encountered Kernodle and Chapin as well, killing them to eliminate witnesses. Two housemates, though, Bethany Funk and Dylan Mortensen, were unharmed. Now, the crime scene was described as profoundly bloody, with multiple stab wounds as defensive injuries as well. A knife sheath with Kohberger's DNA was a critical piece of evidence in, obviously, his guilty plea. Now, after his arrest in Pennsylvania, Kohberger was extradited to Idaho, and Dr. Ramsland reportedly advised his family against delaying extradition, though she denied extensive involvement. Then on July 2nd, 2025, Kohberger's guilty plea spared him the death penalty, a decision that Lieberman criticized, noting his flippant and defiant demeanor during the hearing, showing a complete lack of remorse. So, we talked about this a little bit the other day, but where does Kohberger go from here? So, Kohberger's sentencing is scheduled for July 23rd, with prosecutors recommending the 4 fixed life sentences. Post-sentencing, he'll undergo a 2 weeks of physical, mental, and educational assessment at the Idaho Reception and Diagnostic Unit. That's where they decide where they're going to place him. He is likely to serve his sentence at the Idaho Maximum Security Institution in Boise, which houses close custody inmates and death row prisoners like Chad Daybell, who just happened to be convicted of murdering his wife and his new wife's children. Bad guy as well. The Idaho Maximum Security institution there has 549 residents, and they're primarily in solitary confinement, minimizing interaction. However, Kohberger could be sent to the Seguro Correctional Center in Arizona, as was another Idaho murderer, Marijan Kaler. Now, given the high-profile nature of the crimes and the media attention surrounding the case, Kohberger may face significant risks as a target in prison. Inmates convicted of violent crimes against young victims, particularly, children, women, often attract hostility from other prisoners who adhere to an informal code that views such acts as reprehensible. Now, Kohberger's background as a criminology student who used his knowledge to commit murder could further elevate his notoriety, making him a potential target for violence of harassment. Now, at the facility in Idaho, where most inmates are in solitary confinement, the risk of direct physical confrontation is probably going to be reduced. However, if placed in a facility with a more general population, interaction such as in the facility in Arizona, where the state has a contract with, Kohberger safety could be a little more precarious. Prison authorities will likely consider these factors during his placement evaluation, potentially opting for protective custody or segregation to mitigate threats. So obviously this whole case raises some serious questions about the impact of studying this criminal behavior. Dr. Ramslam's curriculum, while intended to train future law enforcement professionals, may attract individuals with a little darker inclinations, couldn't it? Anyway, his classmates expressed hope that Kohberger's education was not a deliberate step towards murder, but acknowledged he took it completely the wrong way and twisted it. And the parallels to Rogers and Bundy, coupled with Kohberger's own actions, suggest a complex interplay of personal grievances, his academic exposure, and psychological factors. Now, for the victim's family, Dr. Lieberman's theories aims to provide closure, emphasizing that the murders were not due to the victim's actions, but Kohberger's distorted perceptions. As Kohberger faces a lifetime behind bars, his case will likely be studied someday by criminology students themselves. The irony of it, isn't it crazy? Let's face it, the guy's not wired right, gets rejected by women, he hates women, he finds one that looks like the old girlfriend, and then he goes and kills them and everybody else in the path. Ladies and gentlemen, some people just aren't wired right. They really aren't. And he can try to excel to, make it look like he's getting along with everybody, but some people they're just not wired right, ladies and gentlemen. And they're going to wind up there. And, it's tough to say. Obviously he had issues growing up as a kid, and that can certainly shape your future, but it doesn't mean you need to go around killing people. Let's face it, we all know lots of people that were awkward with the girls in junior high and high school, but they didn't go and kill anybody. Now, did they? So can't wait for the 23rd. Can't get here fast enough. But obviously all the theories now of what happened and why, which are legitimate reasons. I think the girls rejected him, found out that, he's a little guy or something, and he just couldn't deal with it. We'll just leave it at that. Next, a Georgia teen charged with murder of her mother and her stepdad. Seems like a nice young lady. So on July 8th of this year, Sarah Grace Patrick, a 17-year-old from Georgia, was charged with the murder of her mother, Kristen Brock, and stepfather, James Brock. Now, the charges, which include 2 counts of murder and 2 counts of aggravated assault, stem from an incident back on February 20th of this year at the couple's house in Tyrus, or Carroll County, Georgia. Now, Patrick is accused of fatally shooting her parents, whose bodies were discovered in their bed by their 6-year-old daughter. Patrick subsequently contacted 911, reporting that she had found the couple deceased. Authorities noted no signs of forced entry at the home, and the door was found slightly ajar with no items reported missing. Now, the Carroll County Sheriff's Office, in collaboration with the FBI and the Georgia Bureau of Investigation Crime Lab, conducted an extensive investigation analyzing substantial physical and digital evidence from the moment the 911 call was received. A relentless investigation began, stated their spokesperson, and of course they wanted everybody to know when they gave their press conference. Anyway, Patrick surrendered to authorities on July 8th after learning of the arrest warrants issued against her. She is currently detained, and prosecutors intend to try her as an adult, and the investigation is still ongoing. We're going to have to follow that one. Killing your parents in bed, your mom and your stepdad in bed, and then calling 911? I don't know. We'll just leave it there. Next, for all of those CrimeTalk aficionados who are total legal geeks, all right, not just in the story and the facts that come out, but the law. And how many times have we talked about what it takes to be a good judge? Judge calls balls and strikes, has no favor, has no prejudice, just calls balls and strikes. This is what the law says. I came across a couple of stories the other day that talk about judicial interpretation. One is a good example of it, and the one not so good. Okay? Like I said, if judges want to make law, they should quit their job as a judge and go become a legislator. When you're a judge, you apply the facts to the law and you make your decision, let the chips fall where they may. You may get the results sometimes you want, sometimes you don't. So let's go into it. So judicial interpretation, all right, the primacy of statutory plain meaning, all right, that's a big deal, all right. That's how things are supposed to be interpreted in the law. The role of a judge in interpreting the law is to discern and apply the plain meaning of statutory text, ensuring that the law's intended effect is realized without injecting personal preferences or desired outcomes. Statutory interpretation demands fidelity to the text as enacted by the legislature, prioritizing clarity and objectivity over subjective judicial agendas. So the principle is critical to maintaining the rule of law and preserving the separation of powers, as judges must resist the temptation to reshape legislation to align with their own views. Two recent cases illustrate the tension between adhering to the plain meaning and the pressure to achieve a specific result, highlighting the judicial responsibility to uphold statutory integrity. So here we go. Now, judges are tasked with interpreting statutes based upon their ordinary plain meaning at the time of the enactment of the law. That's key, ladies and gentlemen. This approach, rooted in textualism, ensures that the judiciary respects the legislative branch's authority to craft laws. And by focusing on the text's clear language, judges avoid overstepping their role and imposing interpretations that reflect personal or ideological biases. The plain meaning rule serves as a safeguard against judicial activism, ensuring that the laws are applied as written rather than as a judge might wish them to be written. So, when the statutory language is unambiguous, judges must give effect to its terms, absent any constitutional violation or clear legislative error. So let's engage in a little case study, all right? A recent ruling by U.S. District Court Judge Amit Mehta exemplifies the challenges of adhering to statutory constraints despite his personal disagreements with the application of the law. In this case, the administration rescinded approximately $800 million in grants intended for violence reduction and crime victim support programs. 5 organizations sought a preliminary injunction to block the rescission, arguing that the Department of Justice's actions were unlawful. Judge Mehta, while expressing strong disapproval of the government's decision, dismissed the case, citing a lack of jurisdiction and the plaintiff's failure to establish a constitutional violation. In his opinion, the judge wrote, "Defendants' rescinding of these awards is shameful. It is likely to harm communities and individuals vulnerable to crime and violence. But displeasure and sympathy are not enough in a court of law," the judge wrote. "This statement underscores the principle of judicial interpretation that must be grounded in legal authority, not emotion or moral considerations. Mehta's rulings reflect a disciplined adherence to the plain meaning of the relevant statute and jurisdictional limits, even when the outcome conflicted with his personal views." And so by prioritizing legal constraints over desired outcomes, Mehta upheld the judiciary's role as an impartial arbiter. Now, let me give you another example. This had to do with the Supreme Court stay on an executive order. The second case, which was before the United States Supreme Court, further illustrates the importance of statutory fidelity, this time in the context of a dispute of Executive Order 14210, which directed federal agencies to plan workforce reduction and reorganization. The court granted a stay of a lower court ruling that had halted the administration's mass layoffs, with Justice Ketanji Brown Jackson dissenting. Now, in her dissent, Jackson argued that the executive order constituted a massive restructuring of the federal government, potentially exceeding legal authority without congressional approval. But her own fellow Justice, more to the left-leaning side of it, Justice Sonia Sotomayor, in a concurring opinion, directly addressed Jackson's dissent, emphasizing that the court's role was not to evaluate the merits of the reorganization plan at this stage. The plan themselves are not before the court. And at this stage, and we have no occasion to consider whether they can and will be carried out consistent with the constraints of the law. She further noted that the executive order explicitly directed agencies to act consistent with applicable law, aligning with statutory requirements. So Sotomayor's response highlights the need for judges to focus on the plain language of the executive order and relevant statute, rather than speculating on potential outcomes or interpreting the law to preventively achieve a preferred result. That's what judges are supposed to do. The temptation to interpret laws to achieve desired outcomes undermine the judiciary's legitimacy and erodes public trust in the legal system. Now, in a separate instance, Justice Amy Coney Barrett sharply criticized Jackson's approach in another case, accusing her of advocating for an imperial judiciary that disregards precedent and statutory constraints. We talked about this the other day. Anyway, Justice Barrett wrote, Justice Jackson would do well to heed her own admonition. Everyone from the president on down is bound by the law. That goes for judges too. This rebuke underscores the danger of a judge's strain from the plain meaning of the law to pursue personal or ideological goals, which can destabilize the constitutional framework and blur the lines between the judicial and legislative functions. So, judicial interpretation must remain anchored in the plain meaning of the statutory text to preserve the integrity of the law and the separation of powers. Judges like Mehta and Sotomayor demonstrate the importance of applying statutes as written, even when doing so yields outcomes that they personally find objectionable. Conversely, deviations from principles, as critiqued by Jackson's dissenting opinion, risks transforming the judiciary into a policy-making body, a role reserved for the legislature. So by adhering to the plain meaning of the law, judges uphold their constitutional duty, ensure that statutory intent is effectuated without distortion by personal desires or external pressures. Now, wouldn't that be nice if judges always just followed the law? Let me give you an example. I once had a motion to suppress in a homicide case, trying to suppress all this bad evidence. And we said the search was bad because under the policy, it said the prosecution or the police at the time had to do A, B, and C. And the judge says, well, they did A and B, but not C. But, there's some case law out there that says that and could be interpreted as an or. The judge asked me what I thought of that. I said, Judge, that would be completely intellectually dishonest. Whereupon she promptly found out that or had the same meaning as and therefore motion to suppress denied. The judge getting to the result that she desired, that she wanted, not what should have taken place. Now, since he was found not guilty of that murder, we never found out who was right, me or the judge. Next, the death penalty was imposed for Ryan Cole for the murders of a 15-year-old. So on July 7th, just the other day, a Florida judge sentenced Ryan Cole, aged 33, to death for the brutal murder of a 15-year-old by the name of Kyler Edmond in Port Charlotte, Florida, following a jury's 10-2 recommendation for the death penalty. Now, Florida is a little different because they have recommendation. If there's more than 8, the judge can impose death. Most states, like Idaho, if there's even one juror that says no death, guess what? He gets life without parole. So you see the dangers. You get one person on there that won't impose death. It's a lot of work. A lot of times you go with the guaranteed result. Anyway, the sentencing marks the conclusions of a case that profoundly impacted the community and the victim's family. Now, Cole's action during a 2019 burglary resulted in the tragic loss of a young life. So back on September 26th of 2019, Cole, under the influence of heroin and methamphetamine and in need of money, targeted the Edmond family home, believing it contained drugs or cash. At approximately 4 p.m., he used a tool to break into the carport and entered the kitchen, where he encountered Kyler Edmond, who was home alone with his 5-year-old sister while their mother was at work. Now, Kyler, in an effort to protect himself and his sister, armed himself with a chef's knife. Home security footage captured a chilling 6-second audio clip in which Cole's voice is heard saying, "Come here, friend," as blood splattered on the floor. This taunting remark, directed at the young boy, underscored the cruelty of the attack. Cole stabbed Kyler 4 times in the chest and abdomen, overpowering him and leaving him to die on the kitchen floor. Kyler's sister, who hid under a bed, was unharmed physically but witnessed the traumatic event. Police later apprehended Cole nearby with blood on his hand from seizing the knife during the struggle. Cole claimed he could not recall the attack. Well, there were several aggravating factors going on in this particular case. So following a trial in 2025, a jury convicted Cole of first-degree murder and burglary. Prosecutors presented compelling evidence to support the death penalty, citing 2 primary aggravating factors. First, the murder occurred during the commission of a burglary, escalating the severity of the crime. Second, Cole's actions were deemed heinous, meaning extremely wicked or shockingly evil, particularly due to the taunting of Kyler as evidenced by the security footage. The prosecution emphasized that Cole pursued Kyler within the safety of his own home, choosing to escalate this confrontation rather than retreat upon discovering the house was occupied. Now, in a memo advocating for the death penalty, prosecutors described Cole's behavior as deliberate and a cruel act of violence against a defenseless teenager protecting his 5-year-old sister. The jury's 10-2 vote for the death penalty reflected the gravity of these factors, surpassing Florida's legal threshold of 8 votes required to recommend capital punishment, as amended by the state legislature following the 2022 Parkland shooting case. Now, Cole's defense attorney, Kathleen Fitzgeorge, argued that a life sentence without parole, contending that it would serve as a slow, humane form of justice that ensures accountability while allowing for reflection and consequences. Fitzgeorge asserted that life imprisonment characterized by confinement in a concrete cell, devoid of autonomy or hope, was a sufficient punishment. However, the argument did not sway the court. Judge Lisa Porter, aligning with the jury's recommendation and the prosecution's position, imposed the death penalty on Cole. And obviously the decision underscores the judiciary's commitment to addressing egregious crimes with the severest of consequences, particularly when they involve the loss of a young life under such cruel circumstances. Now, in a press conference following the sentencing, Sheriff Bill Prumell expressed strong support for the outcome, stating, "There's a special place in hell for individuals like this, and he's getting what he deserves." Prosecutors echoed this sentiment, emphasizing that justice was served for Kyler and his family. And Christina Halston, Kyler's aunt, delivered a poignant statement stating, quote, "Our family is broken. Grief is constant, heavy, and unrelenting. We have birthdays without him. We have holidays without his smile. An empty seat that reminds us every day what has been taken from us." She emphasizes Kyler's significance, adding, Kyler mattered. He still matters. So obviously, the imposition of the sentence for Kyler Edmond serves as a somber reminder of the profound consequences of violent crime. The court's decision, rooted in the jury's recommendation and the aggravating factors, reflect the judicial system's resolve to deliver justice for a young boy who lost his life while protecting his 5-year-old sister. Next on the docket, this day in legal history. On July 9th, 1776, the Declaration of Independence was read aloud to George Washington's troops in New York City, reinforcing the defiance against the British rule and setting the stage for treason prosecutions against loyalists. On July 9th, 1868, the 14th Amendment was ratified, granting citizenship and equal protection under the law to all born or naturalized in the United States, including formerly enslaved people, providing a foundation for civil rights and criminal justice reform. And then on July 9th, 1868, under the Reconstruction Act, Congress began enforcing Section 3 of the 14th Amendment, disenfranchising Confederate loyalists, and advancing federal authority. On July 9th, 1933, the FBI intensified enforcement of the Federal Kidnapping Act, the Lindbergh Law, targeting interstate abductions following high-profile cases such as the 1932 Lindbergh kidnapping. And on July 9th, 1954, the Department of Justice Organized Crime and Racketeering Section began active prosecutions targeting mafia figures and strengthening federal anti-organized crime efforts. And then on this date, in 1965, congressional debates on the Voting Rights Act of 1965 intensified, focused on voter suppression crimes and paving the way of federal oversight of election in discriminatory jurisdictions. And our quote of the day, that's right. The criminal mind often exhibits atypical neural patterns, with research suggesting impairments in areas like the prefrontal cortex and the amygdala, which govern impulse control and emotional regulation. That's from a neurocriminology study by Adrian Rain back in 2013. Prefrontal cortex, right? Dropped as a kid, didn't develop right. That's the whole wiring part. Some people just aren't wired right, ladies and gentlemen. And next, our dumb criminal of the day. Wait till you hear what this guy stole. In a plot twist worthy of a Hollywood caper, two sneaky burglars in Yucapa, California, decided to make a splash by swiping not cash or jewels, but 85 fancy koi fish from the Oak House restaurant. These were not your average goldfish. These prized swimmers nabbed buckets by the bucket under the cover of night, could fetch anywhere from $50 all the way up to $1,500 a piece. Talk about a high stakes fish fry. Anyway, it was all caught on camera. That's right. The fantastic heist unfolded as the culprits raided the restaurant's outdoor pond, leaving owner Sylvia and her husband reeling. How can you trust people now? Sylvia lamented, probably wondering if the thieves had a koi personal vendetta. Anyway, the couple, who's been nurturing these aquatic superstars for 2 decades, watched their beloved attraction for outdoor diners vanish faster than a fish in a net. But don't worry, the San Bernardino Sheriff's Department reeled in one suspect. That's right, 42-year-old David Smith, on suspicion of grand theft after spotting his getaway car on the restaurant's camera. His partner in slime, however, is still swimming free. Of the 85 stolen koi, only 5 have been rescued, leaving the rest likely sold off to somebody's shady aquarium enthusiasts. For now, the Oak House restaurant is left with a pond-sized hole in their hearts and their patio. Here's hoping the remaining crooks get hooked soon and the koi find their way back to calmer waters. That's all we have for today, ladies and gentlemen. Hope you enjoyed the show. Thanks for watching. We'll see you next time. And remember, the Constitution matters.